This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why a statute limited to acts of an insured cannot be used against an insurer, and why a court must read the statute as it is written. In this case, the insured sought to impose damages on an insurer under Tennessee's Fraud Act. Losses, however, claimed under a policy of insurance issued to Plaintiff Volunteer Management and Development Company by Defendant State Auto Property and Casualty Insurance Company resulted in a suit where Volunteer claimed breach of contract and insurance fraud against State Auto and filed a petition to compel appraisal and appoint an umpire. State Auto moved to dismiss the claims under the Insurance Frauds Act agency and sought punitive damages. In Volunteer v. State Auto, the United States District Court for the Middle District of Tennessee, on March 7, 2024, resolved the claims. To survive a motion to dismiss like that filed by State Auto, a complaint must contain sufficient factual allegations accepted as true to state a claim for relief that is plausible on its face. A claim has facial plausibility when the plaintiff pleads facts that allow the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. When a court reviews a motion to dismiss, the court construes the complaint in the light most favorable to the plaintiff, accepts its allegations as true, and draws all reasonable inferences in favor of the plaintiff. Thus, dismissal is appropriate only if it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim which would entitle him to relief. Plaintiff asserted a claim for insurance fraud under Tennessee Code Section 56-53-103(a)(1). Defendant seeks dismissal of that claim because the cited statute applies only to actions of an insured. Defendant, as the insurer, contends obviously it cannot violate the statutory provision because it's not an insured. In response, plaintiff quoted the same statute but omitted the operative phrase, quote, by or on behalf of an insured, close quote, effectively changing the scope of that statute so that its claim is cognizable. The court began, as it must, with the plain language of the statute, and in this narrow respect, plaintiff's response is correct. Clear and unambiguous statutes will be enforced according to their clear terms, as plaintiff also acknowledged, but fails to actually do in its response, that every word of the statute will be given effect. The statute only applies to insureds and cannot apply to an insurer. With regard to an award of punitive damages, defendant is correct that the punitive damages are generally not available in a breach of contract case, and so defendant's motion to dismiss was granted as to the claim for insurance fraud under the code. In my opinion, a plaintiff should never lie to a court. When the insured acknowledged that the statute only applies to fraud by insureds, on appeal it tried to sneak into a fraud case against State Auto by not fully quoting the statute. It didn't work. The fraud statute is limited to fraud by insureds, and there is no way it could be applied against an insurer. This was not even a good try. It was an attempt to defraud the court, and the court generously did nothing more than dismiss that cause of action. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll be given notice of every blog posting, usually 5, sometimes 6 a week. You'll also gain access to the more than 4,750 posts. Please tell your friends and colleagues about this blog and the videos and let them subscribe as well. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.